see. He will make a way for me. He will be my guide. Hold me closely to his side. With love and strength for each new day, he will make a way. He will make a way. Oh, God will make a way where there seems to be no way. He works in ways we cannot see. He will make a way for me. He will be my guide. Hold me closely to his side. With love and strength for each new day, he will make a way. He will make a way. By a roadway in the wilderness, you lead me. Rivers in the desert will I see. Heaven and earth will fade, but his word will still remain. And he will do something new today. Oh, God will make a way where there seems to be no way. He works in ways we cannot see. He will make a way for me. He will be my guide. Hold me closely to his side. With love and strength for each new day, he will make a way. He will make a way. By a roadway in the wilderness, you lead me. Rivers in the desert will I see. Heaven and earth will fade, but his word will still remain. And he will do something new today. Oh, God will make a way where there seems to be no way. He works in ways we cannot see. He will make a way for me. He will be my guide. Hold me closely to his side. With love and strength for each new day, he will make a way. He will make a way.
I use this opportunity to welcome Dr. C. Anita, Assistant Professor, Department of Zoology, to welcome the gathering.
May the abundant blessings of our Lord Almighty quench the thirst of His children at this moment. Good morning, everybody. I feel privileged to take the colossal opportunity to heartily welcome you all on this mentoring session on Introduction to Intellectual Property Rights. Efficiency is doing the thing right. Effectiveness is doing the right thing. Yes. First and foremost, I would like to welcome our Secretary, Dr. Sister Geraldine Jayam. Sister, you show motherly love and give fatherly confidence to all of us at every time. With my thankful heart, I welcome you, dear sister. A leader is one who knows the way, goes the way, and shows the way. One among such leaders is our principal. I would like to extend welcome to our principal, Dr. Sister Annie Purper Sophie, who is the President of Institution Innovation Council of our college. Her endless care, guidance, and support prove that you are a great leader. We are really blessed to have a principal like you. With my sincere heart, I welcome you, dear sister. Next, I would like to extend my sincere welcome to our lovable Vice Principal, Dr. Sister Lima Rose, whose their graciousness is marvelous to all of us at every occasion. With my lovely heart, I welcome you, dear sister. Next, I would like to welcome our Controller of Examinations, Dr. J. Vinolia Josephine Mary. She is kind-hearted and phenomenal to every staff and students. With my that heart, I welcome you, dear ma'am. Next, I would like to extend a special welcome to our guest of honor, Ms. R. Hemalata, Assistant Controller of Patents and Designs, Biotechnology Division, the Patent Office, Government of India, Chennai. She has completed her master degree at Sivanthi Adityanar College, Playarpuram, and also completed her Master of Philosophy at Center for Marine Science and Technology, Manonmaniam Sundarnar University, Rajakamangalam. She was joined in Indian Patent Office, Government of India Service in the year of 2003 as Examiner of Patent and Designs, and she got promoted as Assistant Controller of Patents and Designs in the year of 2015. Nature of her work is examine the patent applications in various branches of patent office in India and disposing the applications based on the merits like granting of patents and refusal of patents, etc. We are extremely grateful for courteously and gladly accepting our invitation and to join with this session today. I welcome you, dear ma'am. Also, I would like to welcome our convener of Institution Innovation Council, Dr. A. Anami Augustus Arul, Department of Botany, Coordinator of Intellectual Property Rights Cell, Dr. Sheba Daniel, Department of Chemistry, and one of our organizing secretary, Mrs. A. Franklin Regila, Department of Commerce. I welcome you all, dear ma'am. Finally, I would like to welcome my colleagues and dear students participants. Welcome you, dear you all. Along with that, I extend my loving and respectful welcome to all those who have joined this mentoring session on Introduction to Intellectual Property Rights. I am sure that you all will feel enriched with knowledge after the completion of this session. Once again, I welcome you all and I hope that you all will have a great time. Thank you.
Thank you, ma'am, for the warm words of welcome. Next, it's time to felicitate the gathering. For that, I would like to request our respected Vice Principal, Dr. Sister Lima Rose of our college.
A pleasant good morning to everyone. I am glad to meet all the participants through this Google platform. I appreciate the initiative taken by the Intellectual Property Rights Cell of IIC of our college in organizing this mentoring session on Introduction to IPR for the selected interested students of our college. IPR is a prerequisite for better identification, planning, commercialization, rendering, and thereby protecting invention and creativity by striking the right balance between the interests of innovators and the wider public interest. The IP system aims to foster an atmosphere in which creativity and innovation can flourish. Students need to learn about IPR as with increasing focus on innovation, research, etc. They need to learn or plan out intellectual property rights to safeguard their invention. Today, we have an eminent resource person, Ms. Hemalata, Assistant Controller of Patents Design, Biotechnology Division, the Patent Office, Government of India, Chennai, to address our students on this topic. On behalf of the management, IAC, and each one present here, I accord you a warm welcome and invoke God's blessings on all of you. At this moment, I congratulate Dr. Anami, convener of IAC, Dr. Sheba Daniel, coordinator of IPR Cell, and organizing secretaries, Mrs. Franklin Regila and Dr. Anita, for their efforts to realize this day. Wishing you all the best. May God bless you.
Thank you, sister, for the kind words. Moving right along, I would like to invite our esteemed resource person, Mrs. R. Hemalata, Assistant Controller of Patents and Designs in Biotechnology Division, the Patent Office, Government of India, Chennai. Over to you, ma'am.
Good morning to all. Be able to hear me? I'll start with very basic of intellectual property right. First one is, what is property? Property refers to and things belong to someone. It's of two types. One is tangible and another one is intangible. Tangible means tangible covers portable asset and stationary asset. Portable assets comprises which is physical in nature, that is, for example, chair, table, etc. Stationary assets are building, land, etc. Here next comes a very important topic. What is intangible property? It covers intellectual property, that is the creation of mind. Intellectual property is of two types. One is industrial property and copyright, which covers patents, trademark, GI, etc. So, the topic what I'm going to cover today is intellectual property. That is, it is divided into two sets. One is industrial property and another one is copyright. Industrial property covers patent, designs, trademark, and GI. I'll continue with the next slide. Intellectual property. As I explained, intellectual property covers patents, trademark, geographical indication, copyright, industrial designs, trade secrets, layout designs of integrated circuits, plant variety infos. That is, it is a creation of mind. Intellectual property, to say in very simple term, it's a creation of mind. Copyright. What is copyright? Copyright is an exclusive right granted to the owner of a literary, artistic, or scientific work to use or authorize others to use it for its reproduction, public performance, translation, and adaptation. That is, copyright is also an exclusive right. It is a right granted to a particular person, that is the owner of any literary work, any artistic work, any scientific work, and he is getting a complete right to reproduce his work, to perform his work, to translate his work, to adapt his work. So this copyright is the condition to register a copyright is it should be original. So if you go back to the previous slides, the copyright is one of the intellectual property which is given for. It's an exclusive right. All these intellectual properties comes under exclusive rights only, and it is granted to a owner of a literary, artistic, scientific work. And by getting a copyright, he or she can reproduce his work, publicly performance, translation, adaptation. I'll go back to the next slide. These are some of the pictures which shows the different areas where you can get copyright. For example, any writing, sculpture work, paintings, lectures, choreography work, maps, cinematography works. For all this, we have to go for copyright. And for technical drawings, any translation work, computer programs, multimedia works, all covers under copyright. Next comes the another important, very important intellectual property right, which is trademark. These are the different symbols where trademark is registered and it is used in public also. You might be aware of all these symbols. First one is for Apple, Pepsi, Honda, MI, Hilton, etc. I'll explain what is the trademark. This is a continuation of that, in which trademark has been registered for Honda, Volkswagen, Dassault, Renault, Maruti Suzuki, etc. Now I will explain what is trademark. A trademark is a sign which can be distinguished from the goods of one traders from those of other. So what is trademark means? Trademark is if you see a particular product, everyone is aware, may be aware of it. There will be a mark TM or TMR. That is, TM is trademark registered. They have applied for trademark, and R is they have already got. It's a registered trademark. So what is trademark? Trademark is a sign. which can distinguish the goods of one trader from that of other. So what is the sign here means? Sign includes any words, logos, pictures or combination thereof. That is any word, that is for example prestige. That is the word. Logo means be registered, any picture or combination thereof. What is the importance of this trademark? Trademark is used as a marketing tool so that customers can recognize the product of one particular trader from that of another's. That is, it differentiates one product from another product, and it is a very important marketing tool. That is the importance of trademark. Trademark, to register a trademark, what are the criteria to register a trademark? The trademark must be distinctive, non-deceptive or contradictory to law or morality, not identical or similar to any earlier marks for the same or similar product. That is, if you have a symbol, if you have a logo, if you have a sign, or if you have a word to which you want to get a trademark, that mark, that is the sign, symbol or mark, what you are having should be distinct from others. It should not be deceptive, it should not confuse others, or it should not be contradictory to law or morality. And the particular mark what you are having should not be identical to a product which is already present. So the mark what you are having should have a distinguished feature from that of the other. This is the explanation for trademark. Next comes the industrial designs. These are the different designs given for seat, jars and chair. So what is the industrial design? Industrial design is the aspect of an useful article which is ornamental or aesthetic. So design is given for ornamental or aesthetic articles. Two-dimensional features like patterns, lines, colors. Three-dimensional features like shape of an article, surface of an article, etc. covers under industrial designs. For example, shape of a handle or body portion of a pressure cooker, for which you can go for designs. So designs must be, what is the criteria for getting a design registered? Design must be new or original and industrially reproducible in order to become eligible for protection. So this comes under industrial design law, where you can protect your design. So it should be also original. It should be used industrially, and if someone is infringing your design what you are having, you have to go for civil remedy only. So as a gist I'm saying, what is design? Design is a design. If you have a design, whether it can be a line pattern, color, mixture of colors, or a shape of an article or a surface of an article, you have to go for designs. Very simple to remember is a shape or a shape of a handle or body portion of a pressure cooker. That is an example for designs. Next comes the very important topic, geographical identification. Now, geographical indication. What is geographical indication, and for what we are getting this geographical indication? Geographical indication of goods are defined as it is also one of the industrial property which is given to a particular group of people. Patent rights, designs, etc. they are given for individual people and also for group of people. But this geographical indication is given especially for a group of people, that is people located in a particular place that is based on the place of origin of that product. This is the basic thing for getting a GI. Typically, such names convey an assurance of quality and distinctivity, which is especially attributable to the origin of the product. That is, geographical identification is given based on the locality, region, or country. Now I go back to the previous slide. Geographical indication is already given for this dolls, Darjeeling tea, Kanjipuram silk sarees, Nagpur orange, and terracotta paintings. So I think now you can understand what is the geographical indication. It is given for, not for ideas, it is given for goods. Goods for a particular society. For example, Tirunelveli Halwa, in our place, Nagarkoil, that temple jewelry designs have got this geographical indication. And what is the objective to get a geographical indication? Marking should not mislead. Economic, it is mainly given for economical prosperity of a country. For example, as I said, Kanjipuram silk sarees, Darjeeling tea, Basmati rice, Kolhapur chappals, Nagpur orange. These are where geographical indications have been given by Government of India. Now, just before going to, this is the next topic is patents. Before going into patents, I'll just explain what I have explained before. First, what is property? Property is of two types, and in that we are mainly concentrating only on industrial property. Intellectual property, that is which covers patents, designs, copyright, trademark. Copyright is an exclusive right given for translation, aesthetic, choreographic, musical, painting, etc. So trademark is given for it's a sign or logo given for a particular product, and design is given for design of a product, and GI is given for a community and place of origin. Now I'll go to an important and a very interesting topic, that is patents. Patents. What is patent? Patent is an exclusive right given by the Government of India to a patentee for a limited period of time for commercial gain in considering the full disclosure of his or her invention. That is, it's an exclusive right. Exclusive means individual right given by Government of India to a patentee. Who is a patentee? Patentee is people like you, researchers, who is coming and apply for patent, etc. How many years patent is given? For a limited period, that is for 20 years. After getting patent, you will get it commercial gain. And how patent is given? When you disclose your invention to the patent office, that is complete and full disclosure of your invention. So I'll recall the thing. Person, he or she is an inventor or assignee or patentee having a invention, that is that it should be in a form of techno-legal document. The invention or your research, what you are having in your hand, should be presented to the patent office in the form of techno-legal document, and this document should satisfy three criteria, that is novelty, inventive step, and industrial applicability. If you are disclosing all this to patent office, an agreement is signed that is based on these three criteria and some other patentability criteria also. Patent is granted based on the merits for 20 years. After getting a patent, you will be commercially benefited. Or you are any apart from this commercially, you can improve your research, everything also. Now, what is the importance? What is the importance of getting a patent? In college level or in higher level, what is the importance of getting a patent? By getting a patent, you are doing a research. And you are filing the research in patent office. You are getting a patent. You can develop the thing, go for marketing, get profit out of it, reinvest it into your research, and come up with different patents. And again, in society, what is the importance of getting patents in society? Society, new products are introduced in the society, in industries, and new services are done, so that the economic level of the country will get increased. Next is, what is the field of technology where patent is granted? Patent is granted in the branch of science and technology. Next, as I already told, what is the criteria for getting a patent? The criteria for getting a patent is a particular invention or research which you are having should pass three criteria. One is novelty, inventive step, and industrial applicability. What is novelty? Novelty, this is the most important criteria, where novelty, if you're having an invention, it should not have been published in India elsewhere. Invention should not have been published in India or elsewhere. That is, it should be very unique and it should be new. That is the meaning of that. Then the invention should not be in prior public knowledge or public use in India. It should not be there in prior public knowledge or prior public use in India. There is one exemption for this, where if you have any research paper, or you might have published your research paper, or you might have presented in any forum or in a local newspaper or anywhere, you can do it. Your paper, you can handle your paper in any way. But when you are coming for patent, after presenting all these things, a period of 12 months time is given. After 12 months only, if you are publishing a paper, from today 12 months time should be calculated, and after 12 months you can come and file for a patent. So novelty is a very important criteria. And novelty, and it should not be elsewhere. The invention should not be published in India or elsewhere. The invention should not have been prior public knowledge or public use in India. And there is an exception when you are presenting it, and you can apply after presenting also. You can come and apply for patent, but the time period given is 12 months time. Next comes the second criteria, inventive step. This is a very important part to get a patent. What is inventive step? Inventive step means a feature of an invention that involves technical advancement as compared to the existing knowledge, or having economic significance, or both, and that makes the invention not obvious to a person skilled in the art. What is inventive step? Inventive step means a future of an invention that involves technical advancement. You might have carried out so many processes in your research, but that process should show a technical advancement as compared to the existing knowledge, and because of this advancement there should be an economical significance which makes your invention not obvious. It should not be obvious to a person skilled in the art. That is the basic for definition for inventive step. The question is there any inventive step arises? Inventive step arises once there is novelty. If you are having an invention in your hand, once if you believe that it is novel, definitely inventive step will be there. That is the meaning. Next is the industrial applicability. Each and every patent is, the third criteria for granting a patent is industrial applicability. That is, the product for which patent is given, or the process which patent is given, should be capable of industrial applicability. That is there should be some industrial applicability for the process or product for which patent is granted. So there are three criteria for getting a patent. One is novelty, another one is industrial, another one is inventive step, and third one is industrial applicability. Novelty means the process or product what you are having in your hand should be new. That is, it should not be published elsewhere in India or anywhere, and it should be new only. Industrial applicability, inventive step means it's a technical advancement. Knowledge will be there, some existing knowledge will be there, but there should be some advancement in connection with the already known process. There should be some technical advancement, and because of this some technical advancement, there should be an economical significance, and this should be non-obvious to a person skilled in the art. That is the thing. And last one is, it should be capable of industrial applicability. That is, it's capable of being made or used in an industry. Either the process or product should be capable of being made or used in an industry. Apart from this three criteria, there are some sections. These patents and this total intellectual property rights are covered by so many laws and sections. So many laws and sections are interconnected with all these intellectual property rights. So there is a section 3 where some inventions are not patentable, non-patentable inventions. That is, first one is section 3A. That is, it is something against natural law. It is not patentable. Second one is discovery of scientific principle, abstract theory, and new property, not patentable. Third one is new use of a known substance, that is second medical use, not patentable. The fourth one is substance obtained by mere admixture, not patentable. Next one is method of agriculture or horticulture, not patentable. Next one is mere arrangement or rearrangement of known device, not patentable. That is something against natural law, means techniques like gambling, they are not patentable. Some discovery of scientific principle, abstract theory, something which you are given in a theory form, it is not patentable. So new use of a known substance, the substance may be already present in the market. If you are coming out with a new use, it is not patentable. Next one is substance obtained by mere mixing. That is, if you are mixing some chemical in water, that is, it is very physical admixture. It is not patentable. Next one is any method of agriculture, that is farming, harvesting, planting of plantation, etc. These are not patentable. Next one is mere arrangement or rearrangement of known device, not patentable. These comes under different section. For example, 3A, B, C, D, that is substance obtained by mere admixture comes under 3E. This agriculture, horticulture comes under 3H, like that. Next is a very important place where patent is not granted for medical purposes. That is, it covers section 3I of Patent Act clearly says that any process for medical, surgical, curative, diagnostic, therapeutic techniques which is practiced on human beings or animals or plants to render them free of disease or to increase the economic value of that particular plant or animal is not patentable. And that is section 3 clearly says that for medical use, that is any surgical procedure or medical things not patentable. Any curative measures not patentable, that is vaccination procedure, immunization procedure, they are not patentable. Diagnosis of a particular disease, it is not patentable. Therapeutic, that is administration of medicine, and those procedures on either human beings, animal or plant are not patentable. And obviously when you are using these procedures, it will render them free of disease or it will increase the economic value of the plant or animal. These techniques are not patentable in India, which covers under section 3A. Next, mere discovery of living or non-living things are not patentable. Mere discovery of living things or non-living things not patentable. Plants and animals that in whole or part, that is, it covers under section 3J, where plants are not patentable, animals are not patentable, even the plant parts or animal parts are also not patentable. Next one is scheme or rule or method of performing act, not patentable. Presentation of information, not patentable. Computer per se, not patentable. That is computer programming, and nothing is patentable in India. Next one, invention related to atomic energy cannot gain a patent in India. Invention related to atomic energy can't get a patent in India. Next one, after getting patent, what is the benefit of getting a patent? After getting patent, you can manufacture or sell, licensing, sell out your product. You can go for cross licensing, improving with your research and development program. After getting one patent, you can go for patent of addition. You can file a divisional application, etc. So what is the benefit of getting a patent? You can manufacture your thing, sell your thing, license your thing, assign your patent to someone. You can go for cross-licensing, improve with further research purpose, protect it with patent of addition or divisional, file a divisional application and go ahead. In Government of India, there are a lot of assistance in filing a patent application. For example, National Innovation Foundation, Indian Innovatives Technology Development Board, that is Department of Science and Technology, TIFAC, etc., where you can approach them for filing a patent. Otherwise, you can directly come to patent office and file a patent. For more information, you can visit ipindia.nic.in website. And you can also write our patent office mail ID. Any doubts or anything, ma'am, regarding this? Thank you so much for listening. Hello?
Yes, ma'am. Yes, ma'am. So, dear students, if you have any doubt, means you ask. If you have any queries, means you ask. Students?
Ma'am, I have some more slides to share. If they are interested, I can present that also, ma'am.
Okay, ma'am. Students?
If possible, you can. Otherwise, if they are having any doubt now, I can clarify and go to the next. I'll just even explain how to file the patent. It will be very useful for them.
So, students, do you have any doubt regarding this?
No, ma'am.
So, shall we continue the session or not, students? Do you want to know about how to file a patent?
Ma'am, I'll just continue one more thing, ma'am, to explain everything.
Yes.
To explain in very simple and to keep it remember them. As I explained that I'll explain one of the example, that is the pressure cooker. If you take a pressure cooker as an example, that is they can understand in a very simple manner what I have explained till now. That is, you imagine a pressure cooker. Patent is given for the constructive future of the pressure cooker. Constructive future, patent is given. Visual appearance, designs is given. Visual appearance.
Excuse me, ma'am. Sorry for the interruption, ma'am. Ma'am, are you presenting any slides, ma'am?
Slides no. I have, ma'am.
Now you are presenting any slide, ma'am?
No, slides if you want, I can go
talking.
No, slides if you want, I can go for this filing procedure, ma'am.
Okay. No need, ma'am. You just explain, ma'am. Okay, ma'am. Explain this pressure cooker detail, ma'am.
Okay. Okay, ma'am. For pressure cooker, patent is given for constructive future of the pressure cooker. Visual appearance, designs is given, and for the trademark, prestige, different names and logos, trademark is given, and for the brochure or booklet, what we get along with the details, you have to go for copyright, ma'am. That is very, very simple form of explaining what I have done till now. Okay, ma'am.
So, students, if you have any doubt regarding this patent or copyright or trademarks, please ask to ma'am. Deepshika, you have any doubt, Deepshika?
No, ma'am. Everything is clarified.
Ma'am, this is a good platform only, but if it is carried out in person, I should have explained more in detail. But the situation is not like that now. So my only aim is to encourage them to get an idea. Then in future they can come up with. So if you are having any research paper or any documentation like that, you can go for either for patents or design something. Some drawing related works or some thing, you can come up. And mainly, I encourage all of you to come and file for patent, because India, in patent office, we are receiving only less number of Indian applications when compared with other foreign filings are more in Indian patent office. So we can take an initiative to come and file for a patent. If you see from outside, it will be very, you may think that it is very difficult to get a patent, how to register like that and all. But once if you started now, the work will become very easy. And I encourage each and everyone who have participated in this to come up with an invention. Come to patent office, approach your professors, your madams, and you come up with the filing. Once if you start one filing now, it will be definitely pave a way for everybody, and everybody can file and will get it. Based on the merits, we are handling Indian applicants. We are very softly. We are there to grant a patent, and you can proceed. I encourage each and everyone. You can now also, you can, if you want, I can show you the filing procedure in short.
Excuse me, ma'am. I have one doubt, ma'am. What is the procedure for that is the writings procedures, ma'am, for applying this, for filing the patents, ma'am?
Writing procedure, ma'am. Simple. Your research paper you might have done, ma'am. That itself is enough, ma'am.
Oh, the research paper is enough.
Yeah. First you have first your title should be there. Abstract of the invention, detailed description of the invention, which should be followed by a claims and an abstract. Description is what you are having in your hand. Claim part is nothing, but you are explaining your research paper in as step by step. That is, the claim should be it's a techno-legal document. It just claims. Claim 1, a process for preparing compound A. That is your claim 1, which explains the how you have carried out your process. Like that, subsequently you can go with claim number 2, 3, like that, ma'am. That is the only part you may face difficulty, but rest of the things are as you are filing your research paper only, ma'am. It should have a title, it should have the summary, it should detailed description of the invention, which is supported by examples, final part drawing, figures, etc. And final is the claim part, where you are going to explain your research paper point wise. That is, if you are having a process claim in your hand, you have to go for a process for preparing a particular compound, like that. And the second claim should be a process as claimed in claim. That is the only difference, ma'am. How many claims you want, you can go ahead and complete your process. And this particular claim should be supported by the description. Finally, one abstract should be there, ma'am.
Ma'am, I have one more doubt, ma'am. For this, some nowadays organic products are there, ma'am. Is it able to get patent for that, ma'am? So for that, in Kerala, I think that is a straw from coconut fiber, like that, ma'am.
Ma'am, actually, if it comes under natural product, it cannot be patentable. Okay, ma'am. But how it is being isolated, that procedure can be patentable, ma'am. How they are taking the fiber or something, that can be patentable. But as a product, it cannot be patentable, ma'am. For example, I'll say in short, ma'am, microorganisms. If you are isolating a microorganism from soil, as such, it cannot be patentable. But if you are taking the microorganism, you are going for genetic engineering technique, and thus genetically modified microorganisms are patentable, ma'am.
Ma'am, what about the selling of that product, ma'am? Suppose that is nowadays people are creating new products like that from organic, this one straw, then from bamboo, like that, ma'am. So the procedure only we can patented only the procedure, not the product.
Not the product, ma'am. Because the thing is, the product is not novel. Only the process of obtaining is novel. The product is already known in nature, so it cannot be patentable. But the process, how you are bringing out, that can be patentable, ma'am.
Without patent, we can sell. We can marketing the product.
Marketing is different, ma'am. Because without applying for patent, without getting the trademark, designs, anything, you can market your product. Once if you get a complaint that you are infringing the product of another person, you will face a trouble in marketing, because that particular person can say that you are using his product. That is the thing. But when you have a patent in your hand, you can argue that this is my product only. I got a patent in this year like this, so this is mine only. That is the difference of getting a patent and marketing, and without getting a patent and marketing, ma'am. That is the thing.
Okay, ma'am. Thank you, ma'am. Thank you for
Ma'am,
clarifying my
just
doubt,
a minute,
ma'am.
ma'am. Ma'am, just a minute. Only one thing I'll say, ma'am. I'll just explain how much money it will cost. Maybe the students, maybe they'll be benefited out of this, ma'am. Because in now we have e-filing procedure, ma'am. 2017 they have introduced the e-filing procedure. In that, for natural person like colleges, universities, etc., or any individual research person, the filing fee for form one is there, ma'am. It is 1000. You have to pay 1600 rupees, and another form 18 for request. You have to completely file you can completely file your research paper. Basic fee is 1600 and 400 for 4000 rupees, ma'am. This is the filing fee, ma'am. And physical filing also there. You can rightly write up all your thing, and you can file in our office also, ma'am.
So which is better, ma'am? E-filing?
This e-filing also okay only, ma'am, because for that you have to go for that signature. Digital signature you have to go, but here also physical filing also immediately after receiving you will get all the receipt, and they'll file. You will get an application number for your invention. Like that it will proceed, ma'am.
Okay, ma'am. Thank you, ma'am.
Thank you.
So students, do we have any doubts, students?
I think everything is clear, ma'am. Then
yes. Now, okay, ma'am. Thank you, ma'am. Ask me a question.
Thank you, ma'am, for enlightening us with valuable talk. We are grateful for the time and effort you took to share your thoughts on copyright, trademark, industrial design, and patent with us, and clarifying doubt. Thank you so much, ma'am.
Okay,
It's time to convey our deep sense of gratitude. For that, I call upon Ms. A. Franklin Regula, Assistant Professor, Department of Commerce.
Good morning, all. Gratitude is not only the greatest of virtues, but the parent of all others. First and foremost, I would like to thank our Lord Almighty for rendering us this opportunity with His countless blessings. Next, I would like to express our deep gratitude to our Secretary, Dr. Sister Gerardine Jayam, and our Principal, Dr. Sister Annie Puppet Sophie, and our Vice Principal, Dr. Sister Lima Rose, and the Controller of Examinations, Dr. Vinolia Josephine Mary, for their cooperation and support. I would like to thank our resource person, Ms. Hemalada, Assistant Controller of Patents and Designs, for her thoughtful, provoking, and very interesting session. The session was awakening the passion and desire to support us as a leader to reach the pole of success. I take this opportunity to extend my sincere thanks to the coordinator of IAC, Dr. Anami Augustus Errol, and the coordinator of IPA of IAC, Dr. Sheba Daniel, for making this mentoring session a great successful one. Finally, it's my immense pleasure to thank the wonderful students who are very enthusiastic and vibrant. Dear students, never give up until you achieve your dreams, and dream big and go for it as long as you can. Success is only for those who work hard and run till the end. So, run to your destination with strong determination. Once again, I thank all for your cordial cooperation. We spread the fragrance of love and renew our obligation. Thank you all.
Thank you, ma'am. I thank each one of you for your active participation in this webinar. Let's all wind up this session. The feedback link is given below in the chat box. Please fill the feedback and receive your certificate from there.
Thank you, dear students. Thank you, sister. And thank you, ma'am.
Thank you very much, ma'am.
Thank you.